The Michigan Supreme Court heard arguments today in a case that will impact the future of a 3-year-old boy who has spent nearly his entire life with his adoptive family.
The court's decision could also affect the state's safe delivery of newborns law, which allows a parent to safely and legally surrender children up to 3 days after birth. Michelle DeSelms is at the live desk with what we know tonight. Michelle?
Yeah, this case surrounds Baby Boy Doe, who was surrendered by his mother to a Grand Rapids hospital back in 2018. Catholic Charities of West Michigan placed the baby with adoptive parents, and the biological parents' rights were then terminated. But as this was all unfolding, the boy's biological father was fighting to get custody. Through divorce proceedings in Ottawa County, the father, Peter Kroitoff, filed a complaint seeking custody of his then unborn child. That was one day before the mother gave up the baby. After the adoption became final, Kroitoff filed a motion in the Kalamazoo court to reinstate his parental rights. The court denied that motion. This all then came to a head when the Court of Appeals reversed the Kalamazoo court's decision, saying a judge wrongly terminated the birth father's parental rights. The state Supreme Court will now address two things: whether a complaint for divorce that seeks custody of an unborn child qualifies as a petition to gain custody under the safe delivery law, and whether the application of the safe delivery law violates the due process rights of an undisclosed father.
Mr. Kroitoff's divorce complaint in this case was filed before there was a newborn. It was filed before there was a surrender, and logically then he could not have been a person claiming to be the non-surrendering parent of a surrendered newborn. The Court of Appeals disagreed with that, of course, and ruled that the divorce complaint, which the Safe Delivery Court, of course, didn't know about, was in fact a petition under the Act. And we obviously disagree with that, and I think the legislative history and the statutory text are consistent with appellant's interpretation of the statute.
That is, I suppose, one of the things that boggles my mind about Catholic Charities' argument in this case, that they say repeatedly, if he would have filed that scale form on day one of birth, or, you know, if he would have filed that scale form, he would have been guaranteed an ability to conduct.
And that's not true?
How can it be true? The practical reality is if he had filed, and again, we're talking about if in any situation, if the Ottawa County Court started its search and didn't find the other court in 28 days, they're arguing there's no legal remedy.
This case has now been submitted for the court's consideration. Of course, he will let you know when they make a decision.